Hi, I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm one half of the Estate Planning Guys. Today I want to talk to you about some common mistakes that people make when they do their estate planning so that you can avoid these types of mistakes. Now, first of all, I want to say that, in my opinion, everyone over the age of 18 should have an estate plan. Even if you don't own very much, when you die, if you don't have a plan at all, it creates a big problem for your family. So having a plan in place that takes care of what happens when you die and how you want things to be handled if you become incapacitated is very important. So the estate plan does two things. I just mentioned those. Number one, it lays out what happens when you die. So it details who's going to take care of things and how your assets are going to be distributed to whom you want them to be distributed when you pass away. The second important thing that an estate plan does that people a lot of times don't think about this, but what an estate plan does is it plans for incapacity. Now, when I use the term incapacity, what I mean is if you have a brain injury, for example, or if you suffer from a stroke, or you have dementia, in layman's terms referred to as losing your marbles, an estate plan details who's going to be able to take care of things for you and what your wishes are with respect to your health care, your finances, that sort of thing. So those are the two big tasks that an estate plan tackles for you. It's really important to have one. So let's talk briefly about what documents are needed for a complete estate plan. The first one is a revocable living trust. Trust is a bucket into which you place your assets, and as long as you're alive and you're competent, you're in full control of the trust. You hold the handle to the bucket. If for some reason you become incapacitated and when you die, the person you've selected will take over the handle to the trust bucket and deal with your assets either for your benefit or for the benefit of your beneficiaries. There's some other videos where I've explained living trusts in more detail. Be sure to look those up if you want more information. The second important document for a complete estate plan is a will. So a will can either be the centerpiece of your estate plan, or in the case of a trust, it can be a contingent document so that if something's left out of the trust, the will provides us with a way to deal with that. We call it a pour over will in a trust plan. The will is a really important piece though for you if either you don't have a trust or even when you do have a trust. The will is a set of instructions for what you want to happen when you die and how you want the assets to be distributed, who you want to be in charge. And one of the other important things about a will is that's the place where you name guardians for your children. If you have minor children and you pass away, someone will have to step in and take care of them. And the will is where you name what's called a guardian who will step in and take care of your children if you pass away. The next important document is a power of attorney. A power of attorney is a document that names an agent called an attorney in fact who can take care of your financial and other personal matters for you if you become incapacitated. So that power of attorney agent will be able to step in and take care of things at your bank or pay your bills or talk with the IRS, all those sorts of things. When you have a trust, a power of attorney is a safety net document, just like the will, but it's an important document to have just in case something's been left out of the trust. The power of attorney will give us a way that we can deal with that if you become incapacitated. The next important document deals with your health care, and it's what's called an advance directive for health care. In some circles, it's been referred to as a living will or an advance directive or a healthcare proxy. So those are all the same document. An advance directive does two things. Number one, it names an agent who can make medical decisions for you if you're unable to communicate. So for example, if you are in a coma and you cannot talk with your doctor, your healthcare agent will be able to make medical decisions about your treatment. The second important thing that an advance directive does for you is it allows you to make a statement about your wishes with respect to end-of-life treatment. So do you want to have a ventilator used? Do you want CPR? What types of treatment do you want, or what types of treatment do you want withheld? The next important document is a HIPAA release. HIPAA is the Health Insurance Portability and Accountability Act. And what it does, among other things, is it restricts the amount of information that medical providers can share with third parties about you. And that's a really great thing. But one of the unintended consequences of HIPAA is that it also prevents your family members from finding out what's going on with your medical care unless you've signed a HIPAA release. Now, when you go to the doctor's office and they give you the clipboard, one of the pieces of paper on the clipboard is a HIPAA release. And it says, I authorize you to talk to the following people about my medical care. And then there's a spot for you to sign and date it at the bottom. That works really well when you go into the doctor's office on your own 2 feet and you're competent. But imagine that you've been in a car wreck and you are unconscious and you go to the hospital. You won't be able to sign a HIPAA release. So we prepare a HIPAA release in advance for all of our clients so that if something happens unexpected, your family will still be able to get information about your medical treatment. So a HIPAA release is a very important piece of a complete estate plan. The next document that's important is called a personal property memorandum. Now, if you've ever had the occasion to read old wills, and by old, I mean maybe they're 100 years old, maybe you've read some of your ancestors' wills, you'll find in those wills that oftentimes they left items of personal property directly in the will. So it would say, for example, I leave my grandfather's pocket watch to my son Johnny. That works fine, but nowadays we tend to turn over personal property proof pretty frequently. So if you think about a watch that you might own, if you're like me, it's probably some sort of digital watch, some sort of smart watch, and it's going to become obsolete in a few years and you're probably going to get a new one. So naming someone in your will that you want to leave your smartwatch to is probably not going to work that well because you're probably going to have a different one by the time that you pass away. So what we've done in modern estate planning is we've taken that personal property out of the will and we put that into a separate document called a personal property memorandum. We reference that in the will or the trust, and it says, hey, trustee or executor, I've left this list of how I want you to hand out my personal property. Now, personal property is basically the stuff in your house, and the law always separate property into 2 different categories. Real property, if you want to think of it in simple terms, is your real estate, and personal property is everything else. And that's somewhat simplified, but for our purposes, that's sufficient. The personal property memorandum is referenced in the will or trust, and it says, I've left this list of how I want you to hand all this stuff out. The personal property memorandum, because it's a separate document from the will, you can change that anytime you want to. You can hand write on that document. Now, none of your other documents would I recommend you hand write, but the personal property memorandum you can hand write. And it's just going to say, I leave this item to this person. And the trustee or executor is going to read that list and they're going to distribute those items the way that you have directed them in that personal property memorandum. Now, the last important piece of a complete estate plan is a DocuBank membership. Now, there are other companies out there that provide similar services. DocuBank is a company that we've used for many years. What DocuBank does is they store a copy of your advance directive and your HIPAA release, and they send you a card that you can carry in your wallet. And that card is about the size of a credit card. And on the front of it has a 1-800 number and a PIN number. The reason that that card is a great thing is you put that in your wallet. If you go to the hospital and you need to have your advance directive or your HIPAA release, you just hand that card to the intake person at the hospital. They call DocuBank. They give them the PIN number that's on the front of the card, and then DocuBank will email those documents or fax if the hospital still uses a fax machine. They'll email or fax those documents into the hospital. That way you have access to those important healthcare documents anytime you need them without having to carry a copy around with you, because who does that, right? So these are the documents that comprise a complete estate plan. Now let's talk a little bit about the kinds of mistakes that I see people making with their estate plans so that you can avoid these mistakes. The first one is people often assume that you have to be rich to have an estate plan. Nothing could be further from the truth. So the term estate, it sounds really fancy. You might think of like the Biltmore estate, for example, but the term estate really just means everything that you own. So if you own anything at all, then you have an estate. And it's important that you have a plan so that your family knows what needs to happen when you pass away. If you don't have a plan at all, it leads to a much lengthier legal process when you die. And it can be a real hassle for your family to have to deal with that. So having an estate plan makes things easier for your family when you die. Likewise, if you become incapacitated, you might not want your Aunt Sally handling your checking account. You may have somebody else in mind. So by having an estate plan, you're going to designate, these are the people that I want to take care of things if I become incapacitated. The second thing, and I've talked about this a little bit already, but the second thing that I see people, the mistake I see people making is assuming that estate planning is just about what happens when you die. Now, I've talked about a couple of important documents that address incapacity. So if you think about incapacity, it's something that we don't know, if that's going to happen to us. It could happen anytime. We all hope that it doesn't, but it's something that is a reality that can happen to you. And so you need to have a plan in place to deal with that, because if you don't, it can be an extremely difficult legal situation. So, for example, I've had clients who had a stroke, and then their children had to step in and take care of things, and they had no plan at all. So that meant that we had to file a petition in the probate court to have that person declared legally incompetent, basically to say that they had lost their marbles, if you will. That is a traumatic experience for a child to go through with their parent, and it's expensive and it can take a long time. We've seen some of these situations take 6 months to wrap up. So during that time frame, everything's just kind of in turmoil and chaos. Nobody knows who can pay the bills, who can take care of what. So by having a plan in place, you're going to name someone specifically to take over if you have some sort of incapacitating event, and they'll be able to step in without having to go through that court process, make sure that your bills get paid, that your mail gets picked up, all of those things that you can't take care of if you become incapacitated. So super important. Next mistake that I see people make is waiting for someone to get sick or pass away to try to make a plan. Now, obviously, after someone's passed away, you can't make a plan at all. So you're just left with whatever the pieces are. You got to pick up those pieces and deal with it. That is a much more difficult legal process than if there is a will or a trust in place. And the other thing that I've seen happen that I mentioned just a moment ago is that sometimes folks get sick unexpectedly. And if there's no plan in place, it can mean that we have to go through a court process to have someone appointed as a guardian or a conservator to take care of just simple things like, where's mom or dad going to live? How are we going to pay their bills? All those sorts of things. Without a plan in place, it is a much more difficult process to deal with. So don't assume that things are just going to work out okay. You need to have a plan in place. The next mistake that I see people making is assuming that if you're single, you don't need a plan. If you're single, you absolutely need to have an estate plan. It's even more important if you're single, because somebody, your brother, your sister, your mom, your dad, your aunt, your uncle, is going to have to step in and deal with things when you pass away, and there won't be any plan in place at all. So we had a client who passed away, and his sister lived across the country. She had to step in as the administrator. He'd left no plans at all. She couldn't come to Savannah to take care of things with that estate. There was an apartment that had all kinds of personal property in it. There was a vehicle. There was all sorts of things that had to be dealt with. And it was extremely difficult for her because she had a busy schedule of her own and couldn't drop what she was doing to come take care of the estate here in Savannah. So it made it much more difficult due to the fact that there was no plan in place. So even if you're single, it's very important that you have an estate plan. The next mistake that I see people make is that they assume that if you're married, you don't need an estate plan. Now, a lot of people think like, oh, well, my wife and I own things together, so if I die, she'll just be able to step in and take care of everything. Now, with joint accounts, that's absolutely true. But if you own anything in your individual name, there will have to be a probate after you die before your spouse can take over and manage things. So it's important that you have a plan in place so that you don't leave your spouse with a really difficult legal situation to deal with. The next mistake that I see people make is assuming that a will is all you need. The one thing I can guarantee you about a will is that it will require a probate when you die. It will require going to court, and that process of having an executor appointed and then wrapping up the estate, it can be a lengthy process. At the short end of things, it's going to take at least 6 months, and sometimes it can take 12 to 18 months to wrap up everything with an estate. If you have a living trust in place, that court process is completely avoided. It makes it much faster and more streamlined with a living trust in place. The person you've chosen as trustee simply takes the handle to the bucket, distributes the assets out of the bucket pursuant to the instructions you've left, and then their job is done. No court to report to, no waiting on timelines and that sort of thing that happen with a probate. The last mistake that I see people make is that they assume that you can do this all by yourself. You probably can do some things by yourself. I love DIY myself. I like to make furniture is one thing I like to do. And that's something that you can figure out how to do on your own, but you probably wouldn't take your medical care into your own hands. And this is a similar thing. You don't know what you don't know. And so it's important to get someone who is an expert in estate planning to help you with putting your estate plan together. Estate planning attorneys are well trained and experienced in dealing with the issues that come up in an estate. And so it's important to find someone to help you who knows what they're doing. Thanks for joining us. If we can help you with your estate plan, please contact us. I hope you enjoyed that video. If you did, then take a moment right now to subscribe by clicking below and turn on the bell notification so you get notified every time we post up a new video. Right now we're posting 3 videos a week with lots of information about various estate planning topics, so you're going to want to make sure to stay on top of that. Click right over here to watch the next most relevant video about estate planning. Go watch it now.